Mr. Scott.
My lady, my lords, I appear with Mr. Burgess for the appellants, to which I'll refer as BHP. For the respondents, the municipality claimants, my own friend Mr. Catherine KC appears with Professor Higgins, Ms. Elvers and Ms. Lawson.
Yes.
BHP appeals with this court's permission against the order of Mr. Justice Constable dated 26th June last year, refusing to strike out these proceedings for criminal contempt. The judge's order is in the core bundle behind tab 4. His judgment, to which we will come, is behind tab 5 in the same bundle. Much of that judgment is concerned with matters that do not arise in this appeal, as to whether contempt proceedings serve the public interest.
Should we just do a little bit of housekeeping, if I may interrupt early on, as you're getting into your stride, which is very helpful. Thank you for the Opus access. I'm being asked to sign in. I'm not aware that I've got anything to sign in with. I don't know whether my lords are in a better position.
I'm in the same position myself.
So if somebody could help us with that, that would be very helpful. Secondly, I'm sure that you and Mr. Kaplan have discussed time estimates and the like. A day will be adequate. And if we are going to hear either from Mr. Burgess or from any of those sitting behind you, Mr. Kaplan, as well, it would be helpful if we could, or if you could identify whether or not any of the issues are going to be divided, and if so, how. I've also not been told that anybody needs a break in terms of the Opus personnel during the course of the morning or the afternoon. Is that correct? Everybody's happy just to sit through unless there are unforeseen developments. Very good. Anything else anybody would like to raise by way of housekeeping early on?
Nothing from our side, Stephen.
No. Thank you. Yes.
I certainly cannot assist with the sign-in on Opus. It may be that those behind me are better placed.
Good.
And perhaps they can busy themselves dealing with that as I continue. In terms of time allocation,
yes,
I have had a conversation with my learned friend. I'm aiming to sit down by around 12:40.
Very good.
For our side, I am aiming to deal with all the issues in the appeal because they are so interrelated. Mr. Kaplan will no doubt indicate a plan when he gets on.
Very good. Thank you.
My lady, as I said, much of the judgment is concerned with matters which do not arise on this appeal as to whether contempt proceedings serve the public interest. The appeal is instead concerned with the judge's prior conclusion from paragraphs 39 to 73 of his judgment that the contempt charge disclosed reasonable grounds such that it should not be struck out. We will need to look in due course and with some care at the contempt charge. The essence of it is that BHP procured and agreed to fund a claim by a Brazilian trade association, IBRAM, before the Brazilian Supreme Court seeking anti-suit relief, which, if granted, would prevent the municipalities from pursuing their English proceedings.
You mentioned paragraphs 39 through to 73, 50 to 73. We don't need to look at paragraphs 40 through to 53, do we?
No.
No. So it's actually really 53 onwards.
Indeed.
Thank you. Yes.
Really, my Lord, it is because of the nature of the relief that is sought by the IBRAM claimants that the present appeal raises a novel issue of general public importance. The issue is whether seeking anti-suit relief in relation to English proceedings amounts to the actus reus of criminal contempt. So far as concerns the novelty of the issue, as the judge acknowledged at paragraph 56 of his judgment, and I quote, "It is accepted by the municipality claimants that there is no English authority that procuring or funding foreign proceedings with the intent of impacting adversely a party's ability to pursue claims unhindered in this jurisdiction can amount to a criminal contempt." The court's note, that's the core bundle, tab 5, page 60. It is not just that there is no English decision that such conduct, or indeed the bringing of foreign proceedings for anti-suit relief in relation to English proceedings, amounts to a criminal contempt. There are no dicta suggestive of it, no straws in the wind. Nor is there any support for the proposition in Arledge or in any other commentary, nor in the work of the Law Commission, which reported in some detail on the law in this field last year and again earlier this year. That is not just the position in England. So far as the party's research indicates, there is no support anywhere in the common law world for the proposition that the seeking of anti-suit relief in relation to local proceedings is a criminal contempt. So far as concerns the general public importance of the issue, that was among the reasons given by Lady Justice Andrews for this court when granting BHP permission to appeal. She said this at paragraph 2 of her reasons: the question whether in principle, and if so in what circumstances, seeking anti-suit relief from a foreign court in relation to English proceedings can amount to criminal contempt is an issue of general public importance, which would justify the Court of Appeal considering the matter irrespective of the strength or otherwise of the legal arguments. That's tab 10 in the core bundle, page 83. We respectfully suggest that the question before this court is one of general public importance for at least two reasons. The first is that the seeking of anti-suit relief itself involves the applicant seeking to have access to a court to protect its own rights or interests. It is a question of general public importance whether conduct of that kind can amount to the actus reus of criminal contempt. As I will develop, there is no English authority to suggest that it can. Insofar as the judge drew support for his contrary conclusion from the cases of Kellett and Dadji, the two authorities to which he referred in the relevant passages of his judgment, we respectfully suggest that neither of them provides any support for his conclusion at all, once they are put in their proper context. The second reason why the question before the court is one of general public importance is that it is inherent in seeking anti-suit relief, that it is done for the purpose and with the intention of impeding the respondent's ability to pursue proceedings elsewhere. That is necessarily the object, and if granted, the effect of all anti-suit relief. The judge concluded that it was arguable that the seeking of such relief amounts to criminal contempt because of the purpose with which it is done. He said this at paragraph 65 of his judgment: insofar as it is established that the IBRAM claim, with accompanying interim relief sought, was intentionally procured and funded by BHP for the purpose of blocking municipality claimants' access to this court in the main proceedings, that is, in principle, capable of constituting a criminal contempt. The judge said his conclusion of principle applied, and I quote from the same paragraph, irrespective of the lawfulness of the arrangement by which the IBRAM claim was procured and has been funded, and the lawfulness of the IBRAM claim itself. That's page 62 of the core bundle. If the judge's analysis is correct, then the seeking of anti-suit relief in relation to English proceedings will always be a crime. And regardless of whether there is any lawful basis for the
Sorry,
relief,
will always be a crime?
crime, criminal contempt. Because the relief will always be sought for the purpose and with the intention of impeding the respondent's conduct of proceedings here. We respectfully suggest that there are principled reasons why seeking anti-suit relief in relation to English proceedings does not interfere with the administration of justice in the sense required to engage the law of criminal contempt. there are also principled reasons why it would be wrong judicially to extend the law to encompass such conduct for the first time.
Do we need to have in mind that there may be dual purposes in some anti-suit cases, based, for example, on an exclusive jurisdiction clause or an arbitration clause? The primary purpose may not be to interfere with the foreign proceedings as such, but may be to protect a private law right, and often, although not necessarily, in support of domestic proceedings. We are concerned I think on the judge's findings, that it is sufficiently arguable for strikeout purposes that the sole purpose in this case was to interfere with the English proceedings.
Michael, let me answer that two ways. Respectfully, we suggest that the distinction that your lordship seeks to draw, dual purposes, is not a distinction that works in circumstances where the interference with the respondent's conduct of proceedings is the corollary of the right that is being asserted. So to take your lordship's example of a contractual right, for example, under an exclusive jurisdiction, the right that is being asserted is a right not to be the subject of the relevant proceeding elsewhere. The relief that is sought is an order preventing the conduct of those proceedings. And no doubt the applicant's intention in seeking it is to achieve just that effect. What your lordship's example puts to me is a situation in which there may be different bases for anti-suit justice relief. And I readily accept that there may. There may be cases of legal rights as the foundation for the relief, or equitable rights, or possibly the need to protect the court's own jurisdiction. The case that this court is concerned with is a case in which constitutional rights under the Brazilian constitution were put forward as the basis for the relief that is being sought. And we respectfully suggest there is no distinction between the basis for the relief that is being sought, which is the contention that the municipalities simply have no capacity to pursue foreign proceedings, and the relief that is sought.
But not BHP's constitutional rights. Not the party's constitutional rights in this case.
Indeed,
No rights at all. No private or public law rights of BHP in this case.
Well, for today's purposes, my lord, I'm bound to accept that, given the judge's findings, but I ought to make clear that that's an acceptance in the context of the debate we're having about strike.
Quite understood.
And I hope that's a point I won't need to repeat. But certainly, I can't today advance any contention that BHP has a private right or a constitutional right under the Brazilian constitution, pursuant to which it could have pursued the claim that IBRAM is bringing. That's without prejudice to where the case may go if it goes any further.
Thank you.
Subject to the court, I was proposing to develop the principled reasons referred to.
Yes, please. Thank you.
In three parts. First, I will develop our argument under grounds 2 and 3, that there are fundamental distinctions of principle between the established categories of conduct that amount to criminal contempt and the conduct in issue in the present case. Those arguments are foundational to the appeal, and my oral submissions will focus on developing them. Let me summarise our argument. We say that the established categories of criminal contempt involve conduct that directly...
Sorry, speaking for myself, you very helpfully signposted 3 parts. Could you just, I know you're developing your first alone, just to settle me down, tell me what the other two headings are, and then go back to your first.
So first point, grounds 2 and 3.
Yes, thank you.
Second part, I will develop our argument that it would be wrong in principle to extend
Yes, I see.
the law to treat for the first time seeking anti-suit relief.
So if you're right on 1, then 2, and then 3?
And then 3 is our argument that this is appropriate for the court to grasp the nettle
Thank
and
you.
deal with the issue today, rather than leave the matter over for determination at trial.
Thank you very
And
much
that's
indeed.
ground 5.
Thank you. Sorry to have interrupted, but now develop your
By
first
way of
ground.
Expectation management. I'm going to take ground 5 very briefly indeed,
Yes.
because I anticipate that having heard the arguments from each of us, the court will have its own view as to whether the point before the court is capable of being dealt with on a strikeout basis, or whether it's more appropriate for determination. We will say the former, but the court will no doubt have its own view, having heard the argument.
So grounds 2 and 3.
Grounds 2 and 3, my ladies. And before I get into them, can I briefly address the background? And I do so very briefly because I'm conscious that 2 members of the court joined in the judgment on the jurisdiction challenge. And so at least those members of the court will be familiar with the wider background to the case. This is a case in which the main proceedings are on foot before the Technology and Construction Court. The detail doesn't matter for today's purposes, but I do need to explain the issues that have arisen under Brazilian law regarding the municipality's capacity to sue. The proceedings were commenced in November 18. As I indicated, jurisdiction challenges follow. BHP succeeded at first instance and then lost before this court, and the Supreme Court refused permission for a further appeal. That was June 23. The parties then progressed the case towards trial. A first stage trial on liability took place between October 24 and March 25. Mrs. Justice O'Farrell gave judgment on the 14th November last year, holding BHP liable. BHP applied to her for permission to appeal. She refused permission in a ruling issued yesterday morning. She extended time for any further application to this court. I think I will be corrected, the time is 28 days, ticking from the ruling yesterday. So that's the current stage of the proceedings below. One of the issues dealt with in Mrs. Justice O'Farrell's judgment, and the one that is relevant for today's purposes, is whether the municipalities have capacity under their constituting Brazilian law to pursue foreign claims. BHP maintained that they did not, and that only the federal state itself has that capacity. And that issue was identified in the agreed final list of issues for the first stage trial at paragraphs 69 and 70. For the court's note, there in the supplementary bundle, tab 9, page 169. They are Brazilian constitutional law issues concerning the powers of and interrelationship between the federal government, the Senate, and the municipalities. We accept, of course, that the English court has jurisdiction to determine these issues between the parties. They were argued out at the first stage trial, at which the municipalities fully participated. Mrs. Justice O'Farrell concluded that they do indeed have the requisite capacity under Brazilian law.
Am I right in understanding that it was your clients who sought to have those issues dealt with at stage 1?
Yes. In reaching her findings...
Sorry, can I just
Of course,
follow up? Would it have been feasible for them to have, for them not to have sought that, and for them to have told the court that they were going to wait until the Ibrahim claim was determined?
So temporarily, I'm afraid your Lordship's question doesn't make sense.
Right.
In this, because the issues were raised, I think, in 2019, the very early stage in the action.
Yes.
It was not until June 24 that Ibrahim's claim was brought.
So by that stage, the issues 69 and 70 had already been formulated as issues which were going to be part of stage 1?
Indeed. Pleaded out, and I think the subject of expert evidence by that stage. Because by that stage, the parties were 4 months out from the first stage trial commencing.
It may not matter at all, but just a point of interest. When was Mrs. Justice O'Farrell informed of the Abraham claim for the first time?
My understanding is she was informed in the run-up to the PTR. And she was so informed as part of the application which the municipality brought for anti-suit injunctive relief to restrain BHP in relation to the Ibrahim claim, which the municipality sought to have come on at the PTR. As it happened, the judge didn't need to rule on the application because it was compromised on the terms of the undertaking.
Yes, yes, thank you.
So that was June,
Yes,
24th of June.
June 24th.
Thank you.
Now, in dealing with the capacity issues in her judgment following the trial, the judge said this at paragraph 1097. It should be emphasised that the role of this court is not to determine the issue as a matter of law, no doubt to the relief of Brazilian constitutional lawyers. The role of this court is to determine the issue in accordance with Brazilian constitutional law, proved as a matter of fact by reference to the expert evidence. And subject to any appeal, the judge's decision disposes of the capacity issue for the purposes of the proceedings between the parties here. But the capacity issues have a wider significance. That is so not just because they involve matters of Brazilian constitutional law, it is also because the issue arises generally in relation to Brazilian municipalities, not just the 46 named in the action before Mrs. Justice O'Farrell. The issues also arise in the context of foreign proceedings brought elsewhere in the name of Brazilian municipalities, in the United States, the Netherlands, Germany, for example. And we respectfully ask the court to bear in mind that wider perspective as we turn to consider the Ibrahim claim and how it has been received by the Federal Supreme Court in Brazil. And as we shall see, the Supreme Court has given directions for the determination of the Ibrahim claim expressly in recognition of the social importance of the constitutional issue that it raises. And if the court would please take up at this point tab 2 of the supplementary bundle. We have here a translation of the Ibrahim claim commenced in the Brazilian court, the STF, so I shall refer to it, on the 11th of June 2024. And the court sees on page 10 of the bundle that Ibrahim is bringing what is translated as a motion for breach of a fundamental precept. The acronym for that is ADPF, on the grounds that are summarised and then developed below. And under the heading Object, the court will please turn to page 12. You see, Ibrahim summarises the fundamental constitutional precepts relied upon, those concerning national sovereignty, the federal system, the organisation and powers of the Brazilian judiciary, and the rules and principles that govern the actions of the public administration. And that is dealt with from paragraphs 1 to paragraph 8, which continue to page 15. And if the court will then please turn to page 16. This section of the Ibrahim claim explains why it is admissible as an ADPF. It says at paragraph 9, and I quote, "The motion is an action for concentrated and abstract control of constitutionality, the purpose of which is to prevent or repair damage to a fundamental precept resulting from an act of public power." And the essential requirements for a motion of that kind are addressed at paragraph 10 on page 16. Short that there be an act of government giving rise to a relevant fundamental constitutional history, and there is no other equally effective means of protection available. And those points are addressed in the IGRM claim down to paragraph 34 on page 28.
Just going back to your wider significance point and references to foreign proceedings brought elsewhere, am I wrong in remembering from somewhere that those foreign proceedings all involve BHP or associated companies?
Your ladyship is not wrong, but the caveat is that the proceedings elsewhere, the proceedings in the Netherlands and Germany and so on, my understanding is that they involve additional parties as well as BHP.
Thank you.
Maybe as I continue working through my submissions, those behind me can actually produce for me a list of the additional parties insofar as we know. But I don't dispute that there are proceedings elsewhere involving BHP.
Thank you.
Now, there are two matters to note at this point regarding ADS under Brazilian law. Each reflects the nature of the process as one to resolve fundamental constitutional issues. Each is common ground. The first is that there is no respondent to an ADPF, which instead seeks a binding determination of the constitutional question raised. I don't ask the court to turn it up, but that is a point made by the municipality claimants themselves in Mr. Neal's first affidavit in support of the contempt application at paragraph 50. That's in the supplementary bundle, tab 12, page 208. So the IGRM claim is not a claim against the municipalities as such, but rather is a special procedure by which to determine the constitutional question erga omnes. The second point to note is that once filed, an ADPF cannot be withdrawn by the party that issues it. That's Mr. Neal's first affidavit, paragraph 80, again tab 12 in the supplementary bundle, page 216. It is that latter feature that leads the municipalities to characterise the IGRM claim as, quote, unstoppable, as they do, for example, at paragraph 2 of their skeleton. And that is also a word which the judge used in his judgment at paragraphs 65 and 91. Some caution with respect is needed about the word unstoppable, because the Brazilian court, the STF, obviously can put a stop to the IGRM claim if it considers that to be appropriate. But it has instead determined that the claim should be proceeded with because of the public importance of the issue that it raises, as we will see in a moment. We would also add that there will be very many cases of anti-suit injunctive relief being sought in relation to proceedings that are unstoppable in the sense that the party who is pursuing them cannot unilaterally bring them to an end, but instead requires the court's permission in order to do so. There are, for example, in this jurisdiction, restrictions on a litigant's ability unilaterally to discontinue proceedings, for example, where injunctions have been sought or where undertakings have been given. The court may well be familiar from its experience in the commercial courts of granting anti-suit injunctions in a form that require a respondent to procure that a claim be terminated rather than unilaterally do so, in recognition of the fact that in some foreign courts, termination of the proceedings requires the involvement of the foreign court. So we do respectfully suggest that the supposed unstoppable feature of the IGRM claim is not a feature which distinguishes this case from other cases involving anti-suit relief in relation to English proceedings. All such relief raises the same issue of general public importance to the court that I identified at the outset of my submission. If we can return to the IGRM claim, and if we can go please to page 28. This section addresses IBRAM's standing to bring the ADPF on the basis that it is, quote, a class organisation of national scope, with the matters raised by the claim affecting its field of activity. And that is developed from paragraph 36 on page 28 down to 52 on page 34. And among the points being made here is that on multiple occasions the STF had admitted IBRAM as amicus curiae. That's paragraph 39. And if we can go forward, please, to page 34. IBRAM here addresses the merits of its case on the constitutional controversy. It does so over some 35 pages. I'm not going to take up this court's time going through it all. The SDF will form its view. What is clear is that from even a cursory review of these pages, the points being raised, sovereignty, separation of powers and so on, they are matters of profound and general constitutional importance in Brazil, just as they would be in the United Kingdom if a group of local authorities were seeking to pursue litigation through, for example, the Brazilian courts, and an issue had been raised about their standing to do so. One would think that is a matter upon which the UK Supreme Court may wish to express its view. The municipality claimants do not allege that the IBRAM claim has no arguable basis under Brazilian constitutional law, nor do they allege that IBRAM brought it, or that BHP procured and agreed to fund it, without believing the claim to be properly arguable, and to reflect what they consider to be the true position under the Brazilian constitution.
I'm not quite sure I followed that. I thought they did argue in England, in effect, that the IBRAM claim would have to fail.
Certainly they join issue with the constitutional point being taken, but there is certainly no allegation in the contempt application or in the affidavit supporting it that the claim was unarguable.
No,
And nor, perhaps more importantly...
They claim it's wrong and they've persuaded the first instance judge to that effect.
Indeed.
But they're not saying it's unarguable.
No. Still less are they saying that it was brought in circumstances where IBRAM and BHP believed it to be otherwise than properly argued. And I make the point to distinguish the present case from at least the hypothetical possibility of cases in which relief is sought in bad faith from a foreign court by a party who knows there to be no basis for the relief that is seeking it, and is seeking that relief for some collateral purpose. That is not the present case. The present case involves an allegation that relief is being procured in Brazil for the purpose of preventing the municipalities from pursuing their action. That is necessarily inherent in the seeking of any form of anti-suit relief. If I can turn to show the court the relief that IBRAM is seeking, we have it on page 69. Now, the STF did not order the interim relief that IBRAM sought back in June 24, and nor has it done so in the intervening 18 months. But I need to show the court how the application was put in Brazil, because that is part of what is pleaded as the basis for the contempt alleged in these proceedings. We pick it up on page 69 at page paragraph 132. IBRAM here explains that a single judge of the STF, a reporting justice, may in exceptional cases grant interim relief to be scrutinised subsequently by the court. And the bases for that are then set out. In short, that there be a sufficiently meritorious case and sufficient urgency for relief. IBRAM then addresses each of those requirements in turn. The merits are dealt with from paragraphs 133 to 134, with IBRAM reiterating its argument on the constitutional question. And then the position on urgency is addressed from page 71 at paragraphs 135 down to 140. And in short, IBRAM's argument in those passages is that the balance of prejudice favoured granting the interim relief sought, pending full examination of the matter by the Supreme Court.
I'm so sorry, it's my fault. Where do we find the interim and the final relief set out in this document?
So, Your Lordship has the interim relief on page 75 at paragraph 141.
That's the interim relief.
That's the interim relief.
But the primary relief is the...
Follows
Yep.
immediately underneath. Perhaps if I can just give the court a moment to read the interim relief sought and the final relief. The key paragraphs are 141 and 144.
So although I think some of the documents have characterised the final relief as only declaratory, is it fair to treat the second half of 144 as seeking final injunctive relief?
Indeed, indeed. And certainly, for our part, we have not sought to characterise it solely as declaratory. There is a declaration in there. IBRAM is seeking a declaration on the constitutional question. But following on from that, certainly final injunctive relief is sought.
Thank you.
And what underlies all of the injunctive relief sought, both interim and final, is IBRAM's case that the municipalities have no capacity to pursue foreign proceedings or take steps in furtherance of that purpose. So this is not a case in which IBRAM is seeking out of spite orders requiring the municipalities to stay their proceedings, cease communicating with lawyers to that end, and so on. IBRAM is seeking that relief on the basis of its position that that reflects a true constitutional position. As I say, the Supreme Court did not grant IBRAM the interim relief sought, nor has it done so in the succeeding 18 months.
It has ordered some interim relief, hasn't
Indeed.
it?
But not this interim relief. This is and the interim relief it has granted is different in nature, but more fundamentally, it's not part of the contempt charge against my clients.
Why is that
That's
fundamental?
because it postdates it.
Why is that fundamental?
Because the proposition that I'm seeking to establish is that the contempt as pleaded in the application notice, the seeking of anti-suit relief, as we characterise it, is not the actus reus of criminal contempt. That's the case I'm seeking to make. There's no case put against my client that IBRAM's obtaining of different interim relief, I think in February 2023, amounts to a contempt. Case is put on the basis of the IBRAM claim as issue. And that's what I'm seeking to do. If there were a case being put in relation to the additional interim relief sought in, I think, February 23, that relief was also in the nature of anti-suit injunctive relief. It sought to interfere to some extent with the interactions between municipality claimants and their lawyers. But the same arguments that I'm making to the court would apply. Just there's no need for the court to grapple with that, because it's not part of the case that was before. As I say, the Supreme Court did not grant the interim relief sought by this claim. What it did was to give directions to expedite determination of the IBRAM claim. Also by order dated 24th June 24. We have that in tab 6 of the same bundle. Can we turn that up? This is a ruling of a single justice, Justice Dino of the Supreme Court. And if we can turn please to page 121. Summarise the proceeding in the constitutional history at paragraphs 1 and 2. Justice Dino says this at paragraph 3. Given the relevance of the raised constitutional matter and its special significance for social order and legal security, the adoption of a summary procedure is appropriate. And in the balance of his ruling, he summarises the IBRAM claim in the ruling sought, adopts the summary procedure and gives directions for the municipalities and the Attorney General of the Union.
And no date has yet been set. No date has yet been set.
So far as I'm aware, no.
No.
As I said a moment ago in answer to my Lord Justice Popplewell's questions, since the IBRAM claim was brought, it is true that IBRAM has sought different additional interim relief. It has done so despite the request made by BHP Brazil that IBRAM not do so. As I say, those developments postdate the alleged contempt, and we say they are not relevant. But, my lady, my lord, you have them addressed as part of the wider background in the judge's judgments of paragraphs 31 through to 38. Can we go next, please, to the contempt application itself? And you have that behind tab 11 in the same bundle.
And why do we need to do that?
You need to do that to understand the case that is being put, and because of a submission I need to make about how mens rea fits
Right.
the issues that the court needs to discuss.
Okay.
So if we can go, please, to 189. The allegation is that the defendants have committed contempt in the face of the court by funding and procuring the initiation of the IBRAM claim, which sought substantive and interim relief that would have the alleged consequences set out in paragraphs 1 to 4. I can just let the court read that.
I think we've, speaking for myself, I've looked at this, yes.
I'm grateful.
And the affidavit in support, yes.
Okay. The judge accepted our submission that the words "in the face of the court" should be struck.
Yes.
And so what remains is the complaint of funding and procuring the IBRAM claim with the alleged consequences there set out. Those consequences are predicated on the relief being granted. That has not happened so far as concerns interim relief, and it would only happen so far as concerns any of this relief if the STF agrees that it is appropriate to grant it, applying its own law. Furthermore, the apprehended consequences that are complained of, were the relief sought granted, they all result from the nature of that relief as a form of anti-suit relief. And that is why the issue raised by this appeal is one of general importance, as I have said. Can I briefly touch on mens rea? The parties agree, and the judge accepted, that to establish criminal contempt in the form of interference with the administration of justice, it is necessary to show that the respondent specifically intended the interference. The judge concluded that while the contempt application itself does not plead that intention, it was sufficiently alleged in the accompanying affidavit of Mr. Neal. And that's paragraphs 49 and 50 of his judgment.
And I'm looking quizzical because there's no appeal against his judgment on this. We're aware of the background. So put together, the affidavit and the contempt application are sufficient. Is there a particular part of the way intention is put in the affidavit that you rely on?
Yes.
Right, so that's paragraph.
So if we can take it up, it's tab 12 in the supplementary bundle.
Yes.
And we can pick it up on page 200. Page 210, I'm so sorry, the
Thank
tab
you.
reference is wrong.
No, that's fine, don't worry. Page 210.
210.
Paragraph 58, the purpose.
Yes, so we pick this up under the heading, the defendant's purpose in
Yes.
procuring the IBAN claim.
Yes.
We begin at 58 with the allegation that it is, quote, clear that the defendants procured the IBAN claim based on the matters they're referred to. Nothing in that addresses the purpose for which the defendants are alleged to have done so.
The heading.
I'm so sorry, Mark.
Say for the heading that precedes it, the defendant's purpose.
Oh, of course. I'm not saying the passage doesn't. I'm just saying the particular paragraph I'm looking at. Paragraph 58 doesn't deal with purpose. That is dealt with at paragraph 59 over the page. And the court will see this. Mr. Neal deposes, the purpose of procuring the IBRAM claim is clear from the reasons given for BHPs to request to file the claim, and interim relief sought in the claim, the timing of the claim and the place where it was filed. And what this amounts to is the allegation that BHP procured IBRAM to seek relief from the Brazilian court ahead of the first stage trial in England for the purpose of restraining the municipality claimants from participating. There is no purpose alleged which is distinct from the consequence of the relief in terms of restraining the municipality claimants from proceeding.
Sorry, I missed that last bit. What's the point?
We say that there is no purpose that is being alleged here distinct from the necessary consequence of seeking and obtaining anti-suit relief. All applicants for anti-suit relief will act for the purpose and with the intention of restraining the respondent from further pursuing proceedings elsewhere.
So the headline point is it's all no different from any anti-suit.
And mens rea, if this allegation is sufficient to make it out, is not a control mechanism pursuant to which the court could distinguish between cases in which anti-suit injunctive seeking anti-suit relief is a contempt and cases in which it is not.
But can I come back to my sole dual purpose, which I quite understand you say is not relevant, but so far as the facts of this case are concerned, on a strikeout stroke arguability basis, it's reasonably apparent that what is being said is that the sole purpose in this case was the anti-suit purpose of preventing the pursuit of the main proceedings and possibly ancillarily the other proceedings. It's not that there was some separate and additional purpose in this public spiritiness, if I can put it that way, of clarifying what Brazilian constitutional law was so far as municipalities were concerned, and certainly not any private rights of BHP.
That's certainly right.
Thank you.
Just going back to your submission, Mr. Scott, if you look at paragraph 59, there's also reference to the interim relief claim.
Yes.
And does your submission hold good by reference to the interim relief that was being sorted here?
Because the interim relief sought was another form of anti-suit injunctive relief. It was relief which sought orders requiring the municipalities to cease pursuing their proceedings.
Well, to cease contact with any of their lawyers.
For the purpose of foreign proceedings.
Yes.
So it's not a general restraint on contact with lawyers, and
No.
that's critical.
No.
It's a restraint on contact with lawyers for the purpose, or I think the word in the translation is with the object of pursuing foreign proceedings. So it's all relief which keys off IBRAM's case that the municipalities have no capacity to pursue such proceedings.
And I think it's also suggested, so far as timing is concerned, that it was particularly timed to put the municipality municipalities in a dilemma as to whether to sign up to the latest Renova/Samarco agreement or miss the boat completely. Is that fair?
It's not a fair description of the pleaded case. The Lordship will not find that allegation in the contempt application itself, and nor is it a point raised in the accompanying affidavit. It is a point that my learned friend raises in his skeleton. Respectfully, we say the point is incoherent, quite apart from being unpleaded. There was no repatriation agreement, as at the time the Ibrahim claim was brought. That the repack comes 4 months later. But even if the court were to take the view that it doesn't matter in a criminal contempt case whether it's pleaded, doesn't matter whether it's coherent, our primary attitude is it's simply irrelevant as a matter of legal analysis.
That I understand.
And can I just go back to bottom this out? Go back to the helpful summary of the interim relief claimed set out at 55 of Mr. O'Neill's affidavit. The suspension of interactions is not limited to the BHP proceedings. It's any claims in any foreign jurisdiction. Is that within the normal ambit of your standard anti-suit injunction?
So, if I can answer my lady's question this way, it is anti-suit relief because it is relief, the nature of which is to restrain the respondent in their conduct of proceedings elsewhere. What aspect is being restrained here? Answer: contact with lawyers for the purpose of such proceedings. Why is this relief being sought?
But sorry, so request the suspension of any new lawsuits and or lawsuits to which they are a party anywhere. Well, those are in the attached list, but the first immediate suspension of interactions is unlimited.
It's unlimited so far as concerns foreign proceedings.
Yeah.
But that's Ibrahim's case. Ibrahim's case is they have no capacity to pursue proceedings outside Brazil.
And you would say that's typical of anti-suit relief, which is sought on the basis of an exclusive jurisdiction clause or an arbitration agreement, which might seek the prevention of any proceedings anywhere other than in the agreed forum.
Indeed. No different from that. One could also imagine this relief being sought in a corporate context. Maybe dispute about who has authority or capacity to represent the company. You can imagine a case in which the court is asked to grant interim injunctive relief, hold the ring, by restraining the continuance of activity which one of the parties alleges is ultra vires the company. But we respectfully suggest that in relation to the issue that the court needs to grapple with on this appeal, what matters is the nature of the relief, not the basis upon which it is sought. The critical question is where you've got relief, whereby an order is sought from the court restraining a respondent from conducting litigation in England, is that capable of amounting to criminal contempt? As the court knows, we say it is not. And that answer does not depend on what the basis for the seeking of anti-suit relief is. It's the submission we make based on the nature of the relief.
You may well be right. What is the basis for your assertion that what matters is the nature of the relief, not the basis on which it's sought? What's the principle behind that submission?
So the principle that underlines the submission is that we say criminal contempt is about direct interference with the English court in its ability to administer justice. And it would be wrong in principle for an English court to regard anti-suit relief as a direct interference. Indeed, it would be fundamentally contrary to the basis upon which English courts themselves grant anti-suit injunctive relief.
So does your submission turn on the correctness of your submission that criminal contempt is about direct and only direct interference?
It doesn't depend on that submission, because we make a further submission that even if the court were to understand the law of criminal contempt to encompass indirect interference, it could only be in cases where they bring improper pressure to bear on a litigant. And again, it would be wrong in principle for the English court to regard the seeking of an anti-suit injunction as a form of improper pressure amounting to a crime.
Well, we're taking you, I think, a little bit out of your order, but just so you know, I do myself have a little bit of difficulty in your characterisation of it not being a direct interference if one had, for example, an anti-suit injunction in, let us say, Russia, which ordered the claimant to cease proceedings in this country on pain of imprisonment. That sounds pretty direct to me, but we'll come to that in due course. Anti-suit relief can be pretty direct, is the point I'm putting to you.
If I can answer my Lord's point this way, and it's the answer which Lord Hobhouse or the Appellate Committee gave in Turner and Grover, a speech with which the other members of the court agree with, in which he was at pains to correct the misapprehension that anti-suit injunctions are addressed to foreign courts. They're not. They're addressed to respondents. But they are, as Lord Hobhouse described it, fault-based remedies addressing the respondent's conduct.
Well, but
Yes, they may have indirect effects.
Well, so may kidnapping the claimant on his way to court. But that would amount to a criminal contempt, would it not?
It would.
That's aimed at the party itself.
Indeed.
Why is a foreign order threatening to lock somebody up if they go to court different in its characterisation?
Because the analogy that the Lordship puts to me, which is no different from the municipality's analogy of blockading the doors to the TCC, with respect, robs the seeking of anti-suit relief of its defining feature. Or seeking a court order. Kidnap is not done pursuant to a court order, nor is barricading the doors to the TCC. What distinguishes the seeking of anti-suit relief is it involves the applicant exercising their own rights of access to justice, putting the matter before another court, and seeking a decision.
So that's a slightly different. It's not the Turner and Grovitt point, that it's addressed to the party, not the court. It is that it's using a judicial process in order to do so. That's the defining distinction in your.
Indeed, we make both points. I accept there may be cases where taking steps against a party to hinder them in accessing the court could amount to criminal contempt. What I do not accept is that seeking a court order is wanton. However much the seeking of the court order may bring pressure to bear on a litigant. So seeking an early trial date may bring pressure to bear on a litigant. So may seeking security for costs. So may applying to have that litigant's statement of case struck. Indeed, the pressure may be so intolerable that the respondent has to come to the table and settle. But no one would argue that any of that involves a criminal contempt.
So bringing proceedings against someone for slander can't amount to contempt if done with the intention of persuading that person to drop their claim. Is that your submission?
There is certainly no authority that the bringing of proceedings amounts to a contempt. There is authority that the making of a threat to your opponent with that intention.
So we're talking about Kellett, obviously.
We're talking about Kellett. Well, why shouldn't it be a fortiori? If it's sufficient that you threaten to bring proceedings, which you may lawfully bring, to bring pressure to bear, if that can be criminal contempt, why should not the actual bringing of proceedings with that intended effect also be a contempt?
Well, there are two distinguishing features of Kellett. First, it's a case of witness tampering. It's got nothing to do with the steps that may properly or otherwise be taken against a litigant. It's about the special position of a witness being considered in the context of perverting the court of justice. The second point of distinction...
Pausing there. If the threat had been made to bring proceedings, defamation proceedings against a party rather than a witness, why would that not equally have been a contempt on the reasoning of Kellett? Why is the distinction between it being a witness and a party different?
So the distinction is one which Lord Justice Stevenson expressly drew between the cases of witnesses and the cases of parties. He drew that distinction by reference to the Webster decision, to which he referred in his judgment, which was a party case, not a witness case. Perhaps I can show the court the authority, because
I'm sorry, it's my fault. I've taken you out of your turn, and if you'd rather deal with this in due course...
So just for finding out, you said 2 points. First of all, Kellett to do with witness tampering. Second headline point.
It's a threat case.
It's a threat case, thank you. And I agree with my lord. Let's get to Kellett when you want. So you say direct versus indirect. What matters is the nature of the relief, not the basis on which it's sought.
And there is the additional point I made in response to my Lord Justice Popplewell's question about the distinguishing feature of this case and all anti-suit cases as involving the seeking of a court order.
Invoking a judicial process.
Yeah.
So Scott, may I just say, every now and again, particularly when you're addressing Lord Justice Popplewell, and when you look down slightly, I can't hear you.
I'm so sorry, my lord, and let me try and remedy that as we go forward. I'm told Opus have asked for a short break in order to remedy the...
All right, thank you. And we promise to allow you to move swiftly through your submissions, and thank you for your patience in dealing with our questions so far. We'll rise. 5 minutes is never enough. 10 minutes, 11:45. Thank you. Limited success, looking at my screen anyway.
Indeed, I'm sorry to hear
All right.
material progress has been made.
Yes.
Before I develop our arguments in relation to grounds 2 and 3, can I correct an answer I gave to my lady's question about the proceedings elsewhere?
Yes.
The Netherlands proceedings do not involve BHP, though they do involve Samarco.
Yes. So I said BHP or associated companies.
The German proceedings do not involve BHP or any associated companies. They involve a collapse at a site that BHP did not operate and was operated instead by Varley.
By who?
Varley.
By Varley, okay. But Varley, is Varley not an associated company? It's a parent company, no?
They were just the joint venture.
A joint venture
Okay.
in relation
Samarco.
to Samarco,
Okay, well,
not in relation to this.
all right.
On grounds 2 and 3, I begin with the nature of criminal contempt and what distinguishes it from civil contempt. And it is that criminal contempt involves conduct that causes or risks causing a serious interference with the court's ability to administer justice. And it is in that sense, we say, that the interference must be direct, must be an interference with the English court in its ability to discharge its function of administering justice. And I want to show the court a number of authorities to illustrate their proposition. They are from contexts very different from the present case, necessarily so, because until this case, no judge has ever suggested that the seeking of anti-suit relief in relation to local proceedings may amount to contempt. So inevitably in this case, one is reasoning by analogy from very different contexts. If we can start please with SFO and O'Brien, tab 23 in the 3rd volume of the authorities.
Yes.
There was a case in which the SFO was investigating the defendant, Mr. O'Brien, for fraud offences. A restraint order had been made against him under the Proceeds of Crime Act. He failed to comply and absconded to the US. In his absence, he was found to be in contempt for breach of the order, and he was later returned to the UK following a request for extradition on fraud offences. He was meanwhile committed to prison for the contempt. He appealed to the Supreme Court. One of the issues was whether his breach of the restraint order amounted to a criminal contempt. Because if it did, he argued that his statutory right of specialty would be engaged since he'd been extradited on other offences. The Supreme Court held that his conduct in breaching the restraint order did not amount to criminal contempt because it did not cause a serious interference with the administration of justice. Lord Toulson gave the only judgment. We can pick it up in the bundle, please, at page 1257. I'm so sorry, it's page 873 in the bundle. 1257, paragraph 35 of the judgment. And having explained at 35 that a restraint order under the Proceeds of Crime Act is an interim remedy in criminal proceedings, and at 36 that the Crown Court has an inherent power to treat the breach of such orders as contempt. Lord Toulson then addresses the distinction between civil and criminal contempt. Can I ask the Court please to read 37 over the page to 39?
Yes.
What we suggest is meant by the requirement of a serious interference with the administration of justice is that such an interference occur in relation to the court, its ability to discharge that function. And that is reflected in the familiar examples that are given by Lord Toulson at 39, quote, physically interfering with the course of a trial, threatening witnesses, or publishing material likely to prejudice a fair trial. All of those things would risk seriously prejudicing the court in its ability to administer justice. Now, the position is to be contrasted here with the enforcement of civil rights. Lord Toulson drew that contrast at paragraphs 41 and 42. His lordship reasoned that it made no difference that the restraint order was made in criminal proceedings because, and I quote against letter H, the question whether a contempt is criminal conduct does not depend on the nature of the court to which the contempt was displayed. It depends on the nature of the conduct. To burst into a courtroom and disrupt a civil trial would be criminal contempt just as much as if the court had been conducting a criminal trial. And the reason is because the nature of the conduct is such that it causes an interference with the court in its ability to administer justice. And if you turn the page, Lord Toulson says this at letter A. Conversely, disobedience to a procedural order of a court is not in itself a crime, just because the order was made in the course of criminal proceedings. To hold that a breach of a procedural order made in a criminal court is itself a crime would be to introduce an unjustified and anomalous extension of the law. And we respectfully submit that to hold that seeking an anti-suit injunction, a court order, in relation to English proceedings is itself a crime, would likewise be to introduce an unjustified and anomalous extension of the criminal law. It would expose a person to a criminal penalty for engaging in the otherwise lawful conduct of seeking access to justice in another court. And it would do so where the conduct does not seriously interfere, indeed does not interfere at all with the English court in its ability to administer justice. And where insofar as there is interference, it is with the respondent, and that is properly the concern of the civil law, including the court's own anti-suit jurisdiction. If we can go next, please, to tab 25. The need for the conduct complained of to cause a serious interference with the court in its ability to administer justice is illustrated by Attorney General and Crossland. This is another decision of the Supreme Court, this time from 2021. It was a case in which the respondent, Mr. Crossland, had represented a charity in proceedings before the Supreme Court, and upon receipt of an embargoed draft of the court's judgment, he disclosed its contents to the press and he tweeted about it. The President of the Supreme Court referred the matter to the Attorney General, who applied to pursue proceedings for contempt, and the application was granted by the Supreme Court and the contempt charge was upheld. One of the issues was whether the contempt was a form of civil or criminal contempt, and the Supreme Court held that it was the latter, Because the nature of the conduct was such as to amount to a serious interference with the administration of justice. We pick it up in the joint judgment of Lords Lloyd Jones, Hamblin and Stevens. They were the panel. If the court will please go to page 898 in the bundle. Can I ask you to read, please, from 22 down to 27 under the heading Civil or Criminal Contempt?
And the point that you wish to emphasise is?
We emphasise in particular the, quote, critical point, as it was put at paragraph 23, that Mr. Crosland's conduct had interfered with the court's control of its own processes, and had done so in a way that was sufficiently serious for the reasons identified at 24 through to 27. And we say that all of those reasons are concerned with the position of the court and its ability to discharge the function of administering justice. And we say it illustrates that what is critical here is if you have conduct directed at the court and which has the consequence of seriously interfering with the court's ability to administer justice.
But are you submitting that conduct which is aimed at the party itself can't be a criminal contempt?
No, but I am submitting that the seeking of an anti-suit injunction in relation to that party.
I quite understand that, but you're emphasising here that what they're talking about is conduct aimed at the court itself.
Indeed.
But, and that is an example of criminal contempt, but criminal contempt isn't limited to such conduct, is it? I mean, the barricading the doors is the, or kidnapping a claimant on the way to court are examples of something which is aimed solely at an individual.
I'm not sure I'd accept that, my lord. In those examples, respectfully, they would appear to us to be situations of conduct aimed at the court. If the court's doors are barricaded, the court cannot discharge its function.
What about the kidnap?
And I would accept that there may be cases in which the conduct that is taken in relation to a party so interferes with the court that the court may be unable to discharge its functions. But they are not the issues that confront the court on this appeal. The issue for the court on this appeal is a distinctive issue about the seeking of anti-suit injunctive relief.
Well, I understand that.
Not only not directed at the court, but is also a process that's mediated through another court.
But one of the things which, it may be said, interferes with the court's ability to perform its functions is if the claimant is coerced into withdrawing or not pursuing their claim.
Respectfully, my lord, we disagree with that. The proposition is contrary to the decision in Webster. Webster was a case in which the threat that was made to a litigant was a threat that the litigant should withdraw their proceedings for trespass, or else their tenancy would be determined. A threat which brought, no doubt, great pressure to bear on the litigant, because if the tenancy was determined, it would have no standing to pursue the claim of trespass any further. The court said it simply isn't contempt. It's a case of asserting legal rights.
That may be a question of looking at what the sole or dual purpose may have been. But if the sole purpose is to prevent the claim being pursued, suppose, for example, that I'm being sued, and I say to the claimant, if you continue to sue me, I'm going to go to the newspapers with some embarrassing photos of you. Could that be criminal contempt?
The question Your Lordship puts to me is difficult to answer because the answer is provided by a statutory strict liability regime. So it would be a publication contempt, the requirements for which are set out in the 1981 Act.
Sorry, I'm not sure I followed that. These are pictures which, if outside the context of the litigation, I would be perfectly permitted to show to the press, and the publication of which would not in any way be a breach of any of the press's obligations. That's the premise. But the reason, I mean, as in any blackmail case in which what you're doing is threatening to do, or maybe threatening to do, is lawful, but the blackmail purpose makes it unlawful. And if the blackmail purpose is to get the claimant to drop their claim, is that capable of being a criminal contempt?
Only in a situation in which the pressure sought to be brought to bear upon the litigant is improper. But in a case in which that which is threatened is a lawful act, the party taking it is within their rights to proceed. It is difficult to see how that could ever be improper.
I understand that point, and that's why you come back to the particular nature of anti-suit relief. But we're on a slightly different point at the moment, which is that it must be direct and it must be serious, and you're showing us authorities of examples of where it's directed at the court itself. And I wonder whether either of those are really the important distinguishing features of this case from your point of view.
Well, can I deal with the hindrance case, which the municipalities put in, which in one way or another your Lordship's questions put to me? And as I hope I've made clear, we accept that there may be cases in which the effect of the conduct is so to hinder a litigant as to prevent a court from discharging its function of administering justice. What we do say is those situations are all very far removed from the case of the seeking of an anti-suit injunction. And if I can deal at this point with the two particular authorities that the municipalities relied upon before the judge, and upon which he relies in his judgment. Can we start with Kellett, please? It's tab 9 in the first authorities bundle. If the court please read the head note which summarises the facts.
Yes.
Three features of Kellett to note before we get into the court's reasoning. The first is that it was a criminal appeal against a conviction for perverting the course of justice. In the course of argument, the defendant appellant conceded that his conduct would probably have amounted to criminal contempt. His argument was that he was not guilty of perverting the course of justice, and it was the requirements of that different offence that were the focus of the debate. So one needs to, with respect, be cautious about extracting too much from Kellett when it was not directly concerned with criminal contempt. That's the first point. The second point to note is that the case was concerned with threats whereby to dissuade a witness from giving evidence. And the central issue for the Court of Appeal was whether threats of that kind always amount to an offence, even if what the witness is threatened with is an otherwise lawful act. The present case has nothing to do with witnesses, nothing to do with threats. The third point to note is that in addressing the threat issue that was before it, the Court of Appeal expressly distinguished the positions of witnesses on the one hand and parties on the other. And on that basis, it distinguished the decision in Webster, which the Court's judgment was given by Lord Justice Stevenson. We can pick it up, please, at page 178 of the bundle. Letter F, please. Having identified perversion of the course of justice as per se an offence against the public weal, His Lordship said at letter G that the authorities show that tampering with evidence, inducing a person to give false evidence, or not to give evidence for reward, are instances of this common law offence, whether the evidence is to be given in criminal or civil proceedings, and whether the inducement is effective or, in this case, not. He went on to note, however, and this is letter H, that all of the authorities were concerned with the manufacture of false evidence or the withdrawal of a true complaint. They do not deal with the limits of the offence or indicate whether it can be committed where the evidence of a potential witness is false or may be false, or whether it can be committed where the means used are not bribery or reward, but threats, or where the threats used are threats to exercise a legal right, or where the intention or one of the intentions of him who approaches the witness is to exercise such a right, or see that justice, or what he believes is justice, is done to himself or another. And they were the issues with which the Lord Justice grappled in the remainder of his speech. There follows a review of the authorities. That's from page 1883 of the bundle. His Lordship accepted that it would not necessarily amount to the offence to attempt to persuade a false witness to speak the truth. But His Lordship said at letter D on page 183 that that could only be done by proper means. If we can go, please, to page 183 of the bundle, letter D. You see the finding about the need for proper means. And His Lordship held that if the means used to dissuade the witness were threats or bribery or force, that would be unlawful, and he supported that by authority considered over the next several pages. And if we can move forward, please, to page 185 in the bundle. His Lordship returns at letter A to the particular issue before the court. He said this: granted that a threat to induce a witness to refrain from giving evidence...
I'm so sorry, it's my fault. Where are you?
I'm so sorry, on page 185 in the bundle, 390 in the report at letter A.
Thank you.
And Lord Justice Stevenson says, granted that a threat to induce a witness to refrain from giving evidence, or to alter or retract evidence which he is intending to give, is an unlawful interference. Is any threat unlawful, including a threat to do a lawful act, namely to exercise a legal right such as to sue in defamation? And he was dealing with that issue solely in the context of threats as a means by which to tamper with a witness for the purpose of the offence under consideration. And that's the basis upon which he distinguishes Webster. And if we can just look at what Lord Justice Stevenson says about that. pick that up from letters B down to H. Can I ask the court please to read that? It's B to H on page 185 in the bundle.
Yes.
As we see, Lord Justice Stevenson did not doubt that Webster was correctly decided, but distinguished it concerned with interfering with a litigant, not a witness. There being, in his lordship's words, quote, a material difference between...
No, well, there may be. I'm not sure he's quite as unequivocal as you suggest.
Indeed, my lady.
But on what basis do you say that that was the basis for his distinguishing Webster?
What is the basis in principle for the distinction?
No, I
between
think
the two
you said that Lord Justice Stevenson drew the distinction with Webster on the basis of facts in Kellett and Webster on the basis that one involved a litigant and one involved a witness.
Indeed. And you see that distinction
Where?
Against letter H at the foot of the page. We think it's significant that in those two cases a different answer was given in respect of witnesses who had given evidence than that which is given in Webster's case in respect of a litigant who had started proceedings. And against letter E, as you lady should put to me, he observes that there may be a material difference between the two cases, witnesses on the one hand, parties on the other, and he supports that with reference to what Lord Simon said in the Times newspaper case.
I understand the submission, but it's slightly odd. I mean, a litigant may also be a witness. If you prevent him from pursuing the claim at all, you're also preventing him from giving evidence. Suppose that the particular conduct, which was said to be a criminal contempt, was not to prevent him bringing his claim at all, but just to kidnap him on the day he was going to give evidence in support of his case. He'd be in exactly the same position as a third-party witness in terms of interference with the process, wouldn't he?
Indeed, but the distinguishing feature we respectfully suggest is that the court, in order to discharge its functions, requires witnesses able to come before it without being tampered with. The position of parties is different because the law tolerates, in relation to parties, greater pressure than it does in relation to witnesses.
Do you want us to go to Webster, did you say?
I am going to take the court to Webster.
Right.
Before we go there, can I just take the court back to the Attorney General and Times newspapers case, which draws, at least in the majority speeches, the distinction I've just identified between the positions of witnesses and jurors on the one hand and parties on the other. With the law taking the position that pressure is not acceptable in relation to jurors and witnesses, it is in relation to parties. We have Times newspapers in, so sorry to jump around. We have it in tab 7 of the First Authorities bundle. question for the Appellate Committee was whether Times newspapers should be restrained from publishing an article that commented upon the issues in dispute in proceedings for damages before the English court between plaintiffs injured by the thalidomide drug and its manufacturer distillers. Now, Times newspapers had already published articles drawing attention to the plight of the victims and their parents and imploring distillers to pay compensation regardless of the legal rights and wrongs of the situation. What distinguished the article proposed to be published was that for the first time the Times newspapers sought to comment on the legal issues that were pending for determination before the English courts. And the Appellate Committee unanimously held that commentary amounted to a criminal contempt and restored an injunction restraining the publication. Different views were expressed on the prior publications. There are 5 substantive speeches extending over more than 30 pages, and in the time available to me I cannot take the court through all of them, and the statements of principle are not all consistent. It is also right to point out that the case subsequently went to the European Court of Human Rights, where there was another split decision, and there followed the enactment of the 1981 Act for publication contempts. We nonetheless respectfully suggest that the majority speeches, particularly Lord Reed's, contain valuable guidance about the general nature of criminal contempt as it has developed at common law. And we can pick it up, please, at page 111 in the bundle. We begin at letter C, for which Lord Reed said it was, quote, necessary to set out some general considerations which must govern the whole subject of contempt. He draws attention to the lack of appellate authority and the need for the Appellate Committee to inject certainty into the field. He then said this at letter D: the law on this subject is and must be founded entirely on public policy. It is not there to protect the private rights of parties to litigation or prosecution. It is there to prevent interference with the administration of justice, and it should, in my judgment, be limited to what is reasonably necessary for that purpose. Public policy generally requires a balancing of interests which may conflict. Freedom of speech should not be limited to any greater extent than is necessary, but it cannot be allowed where there would be real prejudice to the administration of justice. And that passage illustrates the potency, from a public policy perspective, of the need to prevent interference with the administration of justice. Where it applies, it is an absolute requirement. There is no balancing. But that reinforces the need to keep the requirement within proper bounds. To take it no further than is reasonably necessary, as Lord Reed puts it. And at letter H and over the page, Lord Reed quotes the well-known observations of the Chancellor in Reed on the different kinds of criminal contempt. If I can ask the court please to read from letter H over the page to letter D. This passage introduces the position of parties.
Yes.
Okay. So Lord Reed treats this as a guide rather than a straitjacket, and he turns then to consider what abusing parties and prejudicing mankind against them means in modern conditions. His Lordship began by expressing disagreement with the broad approach adopted by the Attorney General whereby any commentary that puts pressure on a party in relation to legal proceedings amounts to a criminal contempt. He said this at letter G. Why should it be contrary to public policy to seek by fair comment to dissuade Shylock from proceeding with his action? Surely it could not be wrong for the officious bystander to draw his attention to the risk that if he goes on, decent people will cease to trade with him. Or suppose that his best customers ceased to trade with him when he heard of the lawsuit. That could not be contempt of court. Would it become contempt if, when asked by Shylock why he was sending no more business his way, he told him the reason? Nothing would be more likely to influence Shylock to discontinue his action. It might become widely known that such pressure was brought to bear. Would that make any difference? And though widely known, must the local press keep silent about it? There must be some limitation of this general statement of the law. And Lord Reed identified that limitation at letter D. He said this: I think there is a difference between direct interference with the fair trial of an action and words or conduct which may affect the mind of a litigant. Comment likely to affect the minds of witnesses and of the tribunal must be stopped, for otherwise the trial may well be unfair. But the fact that a party refrains from seeking to enforce his full legal rights in no way prejudices a fair trial. There are other weighty reasons for preventing improper influence being brought to bear on litigants, but they have little to do with interference with the fairness of a trial. There must be absolute prohibition with interference with a fair trial, but beyond that, there must be a balancing of relevant considerations. And it was applying these principles that Lord Reed concluded that whereas the previous Times publications did not amount to criminal contempt, the proposed publication did, because it amounted to commentary upon the issues that were before the courts. He dealt with the prior publication at page 116 of the report.
Just pausing there. The passage you showed us at 296 might appear to be saying, and I don't know whether this is your submission, that any conduct which is only such as to dissuade a party from seeking to enforce his full legal rights can't come into the category of something which prejudices a fair trial. But he said earlier, at 295D to E, of course, parties must be protected from scurrilous abuse, otherwise many litigants would fear to bring their cases to court. Which suggests he wasn't suggesting that criminal contempt couldn't be committed by putting pressure by some method on a party to make their claim.
No, indeed. We read Lord Reed to be saying that in the cases of parties, you're not in the hard-edged absolute principle of interference with a fair trial that must be stopped, come what may. Where you are is in the situation of balancing competing interests and relevant considerations. So it's the second part of the passage where he says there must be, beyond interference with a fair trial, there must be a balancing of relevant considerations. And as I accepted earlier, we accept that there may be situations where pressure is brought to bear upon a party that is so improper the court is able to treat it as a crime, a serious interference with the court's own ability to administer justice. We just say those situations have absolutely nothing to do with the seeking of an antecedent judge, which, whatever the pressure it may bring to bear upon the respondents, is not improper, where it is mediated through a court process.
I entirely understand that submission. It's not really a question of whether it's direct or whether it's serious in its effects. It's a question of the propriety of the conduct. And as a balancing exercise, you say, if someone goes to a foreign court and invokes rights which, under the local law, they are entitled to invoke and asks the foreign court to rule on it, that is a balancing factor which will make that conduct not improper. Is that how you put it?
We make both of those points. We say this case does not fall within the situation of a direct interference in the sense of the absolute prohibition that Lord Reed identified. And it doesn't do so because an antecedent injunction doesn't interfere with the court, it interferes with the respondent. We say in addition that insofar as it brings any pressure to bear on the respondent, that pressure is not improper, or it is the result of a court order mediated through a court process.
Of course, whenever we grant anti-suit injunctions, we are very clear to emphasise that we are in no way interfering with the foreign court, but only with the litigant.
Indeed, and that is a point we very much rely on, because we say in circumstances where the English court emphasises when granting anti-suit injunctions, they are not directed at the foreign court, they are not a direct interference with its process, they are instead directed at the respondent. Would we say be unprincipled, and indeed smack of double standards, to take a different view of the situation and to criminalise the seeking of an anti-suit injunction in relation to English proceedings on the basis that it interferes with the English court's administration of justice?
Well, the reality of and the practicality of the positions in a jurisdiction battle and the fact that it may ultimately turn not on any particular order of, well, they will turn on orders of the court, but the ability of the parties to enforce them, that is the location of personnel and assets, that was recognised in the follow-up Court of Appeal decision in Unicredit and Ruschem, where Unicredit actually, after obtaining and holding the anti-suit injunction in the Supreme Court, then subsequently applied to discharge its own anti-suit injunction on the basis that Ruschem had obtained further orders in Russia. And this court, when considering whether to discharge a final order, notwithstanding that Unicredit was plainly acting under considerable coercion, nevertheless did discharge, recognising that this is what happens in jurisdiction battles. And certainly there's no suggestion there that there was an involvement of criminal conduct.
We don't have that case, I'm afraid, in the authorities bundle, and we don't have the various other jurisdictional battle cases where anti-suit injunctions are granted and anti-suit injunctions follow from the English court, and then a round of anti-enforcement injunctions. So there are examples of that, for example, in the Masri litigation, which I know at least one of the members of the court is familiar. There is no suggestion in any of these cases involving the most aggressive and well-resourced litigants, not one of them, until now, has suggested that there is a role for the criminal law. And we respectfully suggest the reason is because it is unprincipled for the English court to grant anti-suit injunctions on the basis I have identified, and at the same time criminalise the seeking of them as an interference sufficiently serious with its own function to amount to a crime.
Well, it may depend on the basis on which the foreign court proceeds. Domestically, we grant anti-suit injunctions in support of private law rights, whether they're contractual rights in a jurisdiction or arbitration clause, or an equitable right not to be vexatiously oppressed. One can conceive that maybe exceptionally there may be the invocation of a foreign court's jurisdiction, which is not such a case, and which we would not regard as being in good faith. There may be cases in which there is an improper purpose in that sense. And do I take it it's no part of your submission that there can never be such a case, but that's not your typical
No, indeed.
anti-suit case, and it's not this case.
Indeed, and that is why at the start of my submission I emphasise that there is no allegation of bad faith in the present case. I can see that the question for the court might be different if it were being alleged that IBRAM didn't genuinely believe that the relief it was seeking from the Brazilian court had a basis. But that's not this case.
But that wouldn't be an actus reus point, would it?
No.
No, it would be a mens rea.
Well,
Well,
yes, but as we know, lawful acts can amount to criminal contempt because of the purpose for which they are undertaken. And if we're in that area, which we are if someone invokes the local jurisdiction in a way they're entitled to, that may not be a distinction that holds.
But I would put the distinction respectfully on the basis of putting on one side cases of bad faith, rather than, as I understood my Lord's question to distinguish between cases in which the foreign court is granting anti-suit relief on a basis broadly recognised by the English court.
No, I wasn't putting it on that basis.
I misunderstood.
Because there are many bases on which foreign courts do grant anti-suit relief because of their own jurisdictional rules, which are different from ours. I mean, Texan companies have to be sued in Texas, say, as a hypothetical example. I'm not saying that it has to be circumstances in which we would conversely grant anti-suit relief. As I understand your submission, it doesn't go any further than saying it is relief which is invoked in good faith in the foreign jurisdiction under such rules as apply to that foreign jurisdiction.
Indeed. Recognising that what comes necessarily with the good faith invocation of an anti-suit injunction is that one is doing so for the purpose and with the object of restraining the respondent's pursuit of proceedings elsewhere.
Or another way of putting it is, that may be the ulterior motive, but it's a dual purpose, one purpose of which is to vindicate your local law rights to invoke the local court's jurisdiction.
Indeed.
Just as in Webster, what was said was, if he honestly believes he's entitled to determine the tenancy and does it for an honest purpose, that is sufficient, even if actually the ancillary purpose is also that related to the litigation. Sorry.
Does the timing of the IBRAM claim make this a non-standard piece of anti-suit litigation? I mean, traditionally, anti-suit injunctions are sought at the outset of the offending litigation, not years after the applicant has been embroiled in the litigation, actively participated and put the very same issues before the court.
Well, I certainly accept that if I were before you defending an application for an anti-suit injunction by the municipalities, it would no doubt be argued that the timing of the IBRAM claim was among the features that made it vexatious and oppressive. I would do my very best to rebut the argument. I would draw attention to the profound comity implications in this case, but ultimately the court may be persuaded. But with respect, that does not begin to support the proposition that the seeking of that relief was a crime. And we respectfully submit that analytically, the timing of seeking anti-suit relief in relation to English proceedings simply has no bearing on whether it amounts to the actus reus of criminal contempt. Where it might fit in is to support a bad faith case.
Yes,
along the lines that I was debating
I understand
with
all that.
my Lord.
But
Lord
you say
Justice
this. You say bad faith is not alleged.
Indeed.
And you say improper purpose is not determined by whether this court would itself grant anti-suit or anti-suit relief.
No.
because
Because can I answer my Lord's question two ways? The first is that, to repeat the answer I've already given, the purpose of seeking all anti-suit relief is to restrain the respondent in pursuing their proceedings elsewhere. And either the court takes the view, as did the judge, that that is an improper purpose, or the court accepts our submission that it is not, because it is a purpose inherent in the seeking of all anti-suit injunctions.
but if this court has decided it's an appropriate case for an anti-suit injunction, in one sense it has decided that the purpose is improper and that as a matter of civil law, therefore you should be restrained from pursuing your anti-suit relief abroad.
Indeed, and I don't think...
I just want to understand what your submission is as to why, if it's an improper purpose in the view of the court for civil law purposes, it's not an improper purpose for criminal law purposes.
We say that the two branches of the law are seeking very different purposes. In relation to the grant of an anti-suit injunction, the court is seeking to vindicate equitable rights, to protect the respondent from vexation and oppression. It's an entirely different inquiry, and indeed this is one of the points the municipalities rightly emphasise when one comes to criminal contempt. The inquiry then is whether the conduct interferes with the court in its ability to discharge justice, and does so in a way that is so serious, properly to be treated as a crime. And we respectfully say that the fact that the court has concluded that an anti-suit ought properly be made, that is not analytically relevant to the question whether the conduct in question amounts to the actus reus of criminal contempt. The question for the court is that conduct which causes or threatens to cause a serious interference with the administration of justice?
Now, you've done very well, Mr. Scott, and
Indeed, not
no,
well
you
enough.
have. You've got 20 minutes, I think. We should draw the line. I know you said 12:40, but we've certainly occupied at least 20 minutes. So we will let you conclude your submissions over the next 20 minutes, please.
I'm grateful, my lady. Before we close Times newspapers, which we had open, can I give you the references to the two other majority speeches?
Yes?
With Lord Reed, as
Yes.
to how the two types of publication should be dealt with. There is Lord Morris's speech, which is page 305E to 307F in the report, expressing agreement as to how the two publications ought to be dealt with. And Lord Cross's speech, who expressly agreed with Lord Reed. Again, if I can give you the reference, it's page 322C of the report. The other members of the appellate committee, Lords Diplock and Simon, while agreeing in the overall result, they would also have concluded that the prior publications were contempt because they sought to expose distillers to public criticism for exercising their legal rights. As I say, that was a minority view, but we respectfully suggest that it does not in any event contradict the requirement for an interference with the court's ability to administer justice, and in that sense, the requirement for a direct interference. What it does is to draw the line between direct and indirect interference in slightly different places. But we respectfully suggest it is clear from Lord Diplock's speech, and I don't have the time to take the court through it, that what he regarded as objectionable about holding someone up to public criticism for exercising their legal rights is the impact that that had on the court's ability to administer justice by undermining confidence in the system of justice that had been established, introducing a form of trial by media rather than by the court. I've dealt with Kellett, and I I want to come on to Federal Court Webster in a moment. But before I do so, can I briefly deal with the other decision upon which the judge relied? That's the Daggy case. It was a first instance decision of the Supreme Court of Victoria, before which the plaintiffs have brought proceedings for damages against entities in the same corporate group as these BHP defendants now find themselves. Those proceedings were brought on the basis of alleged activities in Papua New Guinea. Like Kellett, it was a case that didn't involve foreign proceedings at all. Rather, the conduct that was found to amount to a criminal contempt by the first instance judge was requesting the PNG government to pass legislation, the effect of which would have been retrospectively to remove the rights to damages that were being asserted by the plaintiffs in Victoria, and to make it a criminal offence to assert them. And the judge found that that conduct risked interfering with the Victoria Court's ability to administer justice.
Yes.
Whether or not that is correct, with respect, it has nothing to do with the very different situation in the present case. Far from seeking a removal of the municipality claimant's rights, the IBRAM claim seeks a determination of those rights under their governing Brazilian law by the Supreme Court of Brazil, the supreme authority to determine those issues. So we do suggest that neither Daji nor any of the authorities to which the judge in Daji referred provides any support for the judge's conclusion in the present case. Can we go next, please, to Webster? We have that in tab 3 of the first authorities bundle.
Yes.
And in fairness to the judge, I didn't cite this to him. It was not an authority upon which he had the benefit of submission. We do respectfully suggest it is contrary to the conclusion of principle which the judge reached in the present case. The court sees the facts in the headnote. Can I ask you please to read that? The court will then turn, please, to page 302 in the report. You have the argument of the plaintiff charging contempt. The argument is very similar to the one that the municipalities advanced below and advanced before this court. You see in the third sentence, the plaintiff argued, quote, "A litigant is entitled to approach the court free from all restraint or intimidation, and it is a clear contempt of court for any person, whether a party to an action or not, by a threat to endeavour to prevent a party from prosecuting his suit." There is no doubt that the case being put by the claimant was that the threat in Webster was being made for the purpose, the endeavour of preventing the tenant from prosecuting his suit. It's the same hindrance argument that the municipalities advanced before this court. Mr. Justice Neville did not call upon the respondent solicitor to answer it. He must have considered the answer to be crystal clear. He began his judgment by emphasising the importance of the court's contempt jurisdiction, but also the need to exercise it with great care. That anticipates what Lord Reed said nearly 70 years later in Times newspaper. And over the page, 303 of the report, page 23 of the bundle, the judge explains, against the sidelined passage, why there was no contempt in a case such as was before him. Can I ask you please to reread that passage? Now, the municipalities say in their skeleton, this is at 47, that the decision in Webster turned on mens rea. Respectfully, we disagree. Plainly, the purpose of the solicitor's threat was to interfere with the tenant in relation to the proceedings. It sought to force the tenant to withdraw. That was the endeavour referred to in argument. Mr. Justice Neville cannot have considered that that was sufficient to amount to criminal contempt, where the threat being made was to assert legal rights. Equally, and as the judge noted, the purpose, the object, as depicted in the sideline passage, of actually determining the tenancy, likewise that would have been to interfere with the yearly tenant in relation to the proceedings by removing his standing to pursue them. And again, that was not sufficient to make the conduct criminal contempt. The judge said there was no contempt in a landlord exercising his legal rights in this way if he does it honestly to protect the rights he had. Which brings me back to the debate I had with my Lord Justice Popplewell about cases such as this, in which you have the assertion of legal rights, being cases in which there is not a criminal contempt.
But that expression was picked up by Lord Justice Stevenson. He does it honestly to protect the rights he has in the property.
Indeed.
Suggests a dual purpose rather than the sole purpose of defeating the claim.
Indeed. It may well be that the case can be analysed as involving dual purposes, but if that is right, the same analysis applies in the present case. The case involves the purpose both of asserting constitutional rights in Brazil, of profound importance to BHP, because if BHP's position is correct in respect to those constitutional rights, there is no basis for the action here to proceed.
Yeah.
And also for the purpose as a necessary corollary of those rights, of stopping the proceedings being pursued by people who have no capacity to pursue. My Lord, can I turn next to grounds 1 and 4, the second part of my submission?
Two, sorry.
Grounds 1 and 4.
Yes, certainly.
These are concerned with the question whether, if the court agrees with me so far, it should nonetheless extend the law of criminal contempt to encompass the seeking of antecedent injunctions in relation to English proceedings. And we respectfully submit that there are two principled reasons why it should not do so. First, we respectfully suggest that such an extension would be contrary to the court's proper constitutional function. It would involve extending the criminal law to a new situation which has never before been treated as a criminal contempt, with there being no straws in the wind, as I put it earlier, to suggest that criminal law applies to this type of case. And we set out in writing the bases for that argument, both under the Convention and the common law. The municipality...
Could you just give me a paragraph reference in your skeleton? Or somebody
Certainly
behind you
can.
can. Don't worry, carry on. I'm sure
I
somebody can
can
give it
come
later.
back.
Thank you.
The municipality's primary argument in response to this, and this is paragraph 28.1 of their skeleton as developed at 29 and following, is to say that the point we make doesn't arise because they say that they seek, and I quote, the orthodox application of the existing law to a new variation of conduct. And I accept that if that is the right characterization of their case, the arguments we make on extending the law do not arise. But where we join issue with them is on whether that is the correct characterisation of their case. If the court accepts their argument that this case is analogous with the forms of hindrance to which Arledge refers, then obviously no question of extending the law arises. But if the court accepts our submission, that there are principled reasons which distinguish the seeking of an anti-suit injunction from the cases so far held to be criminal contempt, then the question arises, well, should the court extend the law to this new kind of conduct for the first time? And the court has our submission that to do so would be constitutionally would not reflect or be consistent with the principle of reasonable use in criminal matters. That's what we say under ground one. We give a further or alternative reason why it would be wrong to extend the law in this way, and that's because there is simply no need to, given the court's own anti-suit jurisdiction. And we say that to extend the criminal law into this field would risk dangerous consequences, and that's ground four. And I confess I'm going to have to use the F word, floodgates, here on a number of occasions. But we do say that the judge's analysis and conclusion will very considerably open up the floodgates, and particularly in cases of jurisdiction battles. Criminal contempt will be a new string to the aggressive litigant's bow. Now the judge rejected our arguments here. We respectfully suggest he was wrong to do so for 5 reasons. I can just give the court those reasons. The first is that he misunderstood our argument as being about ouster of the court's contempt jurisdiction pursuant to the court's anti-suit jurisdiction. And the court will see that in his analysis on page 63 of his judgment. He said, it simply cannot be right that the court's inherent power to police acts of interference in the proper administration of justice through criminal contempt has been ousted by reason of the anti-suit injunctive powers and associated civil contempt jurisdiction. We are not making an ouster argument. Our argument is that it would be wrong to extend the law on criminal contempt to cases which have for more than 2 centuries been dealt with by the court's anti-suit jurisdiction without any prior suggestion that there is a role for the criminal law. The second reason is that the judge relied on Kellett and Daggy. He was wrong to do so for the reasons I have developed. The third reason we say the judge erred is because at paragraph 70, he took the view that the facts of this case, as he put it, quote, at least arguably demonstrate that there may be cases where the anti-suit jurisdiction may be inadequate properly to deal with the act of interference. And we offer 2 responses to that. The first is that the power that the court has in granting anti-suit injunctions is extremely broad. The power to grant whatever injunction the court considers to be just and convenient, wherever the ends of justice so rely. So the court would have had, for example, in the present case, the power to make an injunction restraining BHP from funding the IBRAM claim, the power to restrain IBRAM from further pursuing it. And of course, in this case, the municipalities obtained anti-suit relief against IBRAM. The court would also have had the power to require IBRAM to use best endeavours to procure that the claim not proceed any further, and specifically to petition the Brazilian Supreme Court for that purpose. The municipalities could have sought all of that relief, but they never did. What they instead have done is sought to turn this dispute into a dispute about criminal contempt. Now, there may well have been principled reasons why the court would not have granted relief of the kinds I have just articulated. Perhaps the court would have considered it unnecessary. Perhaps it would have considered it unjust or inconvenient or contrary to comity. But that does not mean that the jurisdiction would be inadequate. Still less does it mean that the law on criminal contempt should be extended into this new field for the first time. The fourth criticism concerns the judge's observation at 71 that it was inappropriate to decide this point on a strikeout application. We respectfully disagree. The point is ultimately one of principle. It will not look any different at trial. And the final criticism concerns the judge's assessment at 72 of his judgment on the floodgates. He thought his decision was unlikely to open any floodgates. Respectfully, we disagree. His reasoning and conclusion, if correct, will apply to all attempts to seek anti-suit relief in relation to English proceedings. If the mens rea alleged in this case is sufficient, it will provide no safety mechanism to distinguish between those cases which are crimes and those which are not. Insofar as the municipality suggests that a control mechanism is provided by treating such contempts as technical ones in an appropriate case, or because of the general requirement that contempt proceedings receive a public interest. With respect, neither of those points is a satisfactory mechanism. And it's difficult to see how either of them would hold the line. Because once the court accepts that conduct of this kind amounts to the actus reus of criminal contempt, and therefore a serious interference with the court's ability to administer justice, it is, with respect, very difficult to see how that could be dismissed as trivial, or why it would not be of the public interest to pursue such proceedings. And respectfully, the error, and that which opens the floodgates unjustifiably, is to treat this conduct at all as the actus reus of criminal conduct. Lady Mayor, finally on ground five, I have nothing to say in addition to what I said at the outset. We do respectfully say this is an appropriate case to grapple with the issue of principle. I've made the argument on the level of principle. I expect Mr. Kaplan will do so when he gets on this week. But ultimately, the court will have its own view of whether this is appropriate for now or for trial.
Well, thank you.
If I can assist you
No,
further,
you've
those
done very
are-
well, Mr. Scott. Thank you very much indeed. Not at this stage. We will, of course, have a right of reply. And Mr. Burgess, this is not really an invitation, but do you follow?
I don't.
Good. Well done for keeping in time. We will, of course, remind ourselves of the skeleton arguments which we've read in detail in preparation for today's hearing, so rest assured of that. And we look forward, Mr. Kaplan, to hearing from you at 2 o'clock. Thank you.
All rise.